Good morning, guys. I'm John Sirigo with TMPA. Hey, listen, we've been getting a lot of questions over the last few weeks from our members about the COVID-19 vaccine and whether or not they must take it if they're ordered to do so. So this morning, I am visiting with probably one of the most respected and experienced law enforcement attorneys in the state of Texas, Bob Gorsky. Bob's been representing our members, DPSOA's members, and DPA's members for decades. So you're not going to get better legal advice than what you're going to get from Bob. So with that, I'm going to turn it over to Bob, and Bob, ask you a simple question. If we have members who are ordered to take the vaccine and they don't want to take it, what next?
Well, good morning, John. We're dealing with an historic pandemic and wading into waters that we've never seen before. There are no statutes directly on point regarding the COVID vaccine, and certainly there's no case law at this point regarding the issue of refusing to take a COVID vaccine. There are cases that deal with flu vaccine that support the notion that the vaccine can be mandated. However, we have a few statutes that in some cases may allow a member to refuse to take the vaccine or at least deal with their employer in an effort to obtain some type of reasonable accommodation. The first of which is the Americans with Disabilities Act. So individuals who qualify under the ADA and have an impairment and a medical condition that meets the ADA's definitions and standards may have the ability to obtain a reasonable accommodation if they can show that taking the vaccine is going to cause serious medical harm to them. That would entail the employee advising the employer, the department, or the agency that he or she has a condition, providing proper documentation of the condition, and then if the employer can reasonably accommodate, then the employer has that obligation. One of the problems in this regard, and I don't want to get too deep in the weeds on further complications, are that the EEOC in the case law has been very favorable towards employers in determining what their essential job functions are. So if you have an employer that says, we just can't put this person on a desk job because we don't have the manpower, or we can't find another position because of the nature or size of our department, that may give the employer a reason not to provide an accommodation. But sometimes the accommodation may be as simple as just a leave of absence for the employee who feels that they cannot take the vaccine for these reasons. It may be a reassignment. It may be separating them in the workplace. There obviously are a myriad of different options that might be available. The other issue, or another issue that comes up regarding medical conditions, would be under the Pregnancy Discrimination Act. If a pregnant individual has a medical condition arising from her pregnancy, which may be implicated by the vaccine, again, with proper documentation, may provide some type of protection there. The final statute that I'd call to your attention would be the Civil Rights Act of 1964, Title VII, dealing with religious convictions and religious accommodations. So if an employee has a religious conviction that would prevent him from taking the vaccine, and that, again, needs to be presented to the employer requesting an accommodation, while the courts and the EEOC suggest that the employer take that conviction at face value if there's some objective evidence on the employer's part that the person doesn't really have that religious conviction but is using it only as an excuse, the employer can require some type of evidence supporting the fact that they do hold those beliefs. So we have some statutes to work with. I guess I'd say the general rule is your employer has the right. Of course, you don't have to take any vaccines, but we're talking about how do we do this without facing some type of disciplinary action or even termination. And while the employer has a general right to mandate the vaccine, there may be some avenues for the employee who has a legitimate reason not to take it. As with any order that might raise some type of an issue, and we have these types of things that come up from time to time in other contexts, we always encourage the employee to try to work it out through the chain of command, through with the help of a friendly supervisor, a TMPA rep, or even the employee's attorney. Don't just jump off the deep end and refuse to take something. Try to see if this can be worked out. First thing would be to work it out while still maintaining your job and getting your paycheck. But if it really entails, a need for just a leave of absence with or without pay, we may have to approach it on that end. So those are the things I would encourage employees to do. Hopefully you'll have some heads up on how your employer is going to handle the vaccine and what it will mandate or not mandate. So there'll be some lead time to try to work out these issues as we go along.
Okay, so bottom line, if a member has a legitimate reason to not take it, Title VII, ADA, pregnancy, and they can't work it out through their employer, they need to give us a call.
Of course, definitely.
Okay, awesome. Well, I don't have any questions. I think you pretty much covered all of it. Bob, we really appreciate you. We really appreciate what the firm does and all the lawyers in the firm. You guys have a safe and Merry Christmas and New Year's. And again, on behalf of all the members, thanks, Bob. We really appreciate it.
Thank you, John. Merry Christmas. Happy New Year. Everyone be safe. We're here if you need us.
We're here 24/7. Thanks, Bob. Take care, guys. Bye-bye.